Please take your seats. We will now go to the second round of oral pleadings, and we are going to start with the applicant. Representative of the applicant, you have 30 minutes to respond to the questions that were asked, but also you can speak to the issue that you feel you need to speak about from the intervention by the respondent. So you have 30 minutes plus the 11 minutes, but as I said, you don't have to take all of it.
Thank you, Honorable Vice President, Honorable Justices, for this opportunity to further address the court and answer the specific questions that was brought to the applicant. In our understanding, 6 general questions was brought, 6 directly and 2 questions further that both parties were requested to answer. If so, what is the proof of that claim? The case of the prosecution remained mostly circumstantial, as shown by the own admission of the prosecutor and the findings of the first assistant. This was further confirmed by the Court of Appeal while upholding the conviction of the applicant when stating at page 16 of its judgment that there was no dispute that the applicant was convicted based on circumstantial evidence. May it please the Court, I would like to read page 16 as referred to for the evidence out. There is no dispute that the prosecution case against the appellant was exclusively based on circumstantial evidence, which, simply stated, means evidence that relies on the inference to connect it to a conclusion of fact rather than direct evidence. In other words, it is proof of the existence or non-existence of an alleged or disputed fact based on reasoning and not on personal knowledge or observation. Further, in the same judgment of the Court of Appeal maintaining the conviction of the applicant at page 22 this time, the appellant stated that their quarrel on the morning of 4th of October 2005 centered on the deceased's skirt, which he said was too short. The big question is, was it a coincidence that besides the deceased's body was her own skirt? Since there was no evidence to suggest that Angèle was raped before she was killed, as was found by the trial court, why would any other killer tear her skirt? In our settled view, the deceased's own skirt besides her naked body implies a link with the couple's quarrel in that connection. In other words, it implies that it did not part ways with her at the main place, and he perpetrated in his defense. These findings demonstrate, and that's the finding of the Court of Appeal in its judgment at page 31, that there was indeed contradictions in the witness testimony that existed, but the judges found that these contradictions were inevitable. And if you please the Court, I would like to finalize this argument by reading the last paragraph at page 31 of the judgment of the Court of Appeal. With great respect, on our part, we find that there is no controversy that there was such contradictions in the evidence of the witnesses covered above, and that those contradictions were not resolved by the trial court as it ought to have done. However, as we have already pointed out in this judgment, this being a first appeal, we could have, in a proper case, embarked on reconsidering and evaluating the evidence ourselves with a view to resolving the said contradictions for which we could come to our own conclusion, bearing in mind, of course, that we never saw the witnesses as they testified. However, we do not intend to do so in the circumstances of the present case for reasons we are about to assign. So these were the conclusions of the Court of Appeal, which confirmed the own assessments of the prosecutor and the first assessor in determining that the conviction of the applicant was based solely on circumstantial evidence, and circumstantial evidence that was marred by contradictions in the witness testimonies. The second question we had, in the way that we understood it, is in terms of the treaty provisions with the UN, it was the responsibility of the UN to inform the state of Côte d'Ivoire of him being detained. This was the position of the respondent in its oral submission this morning. The applicant later on sent a letter to the UN Secretary General admitting that the ICR was responsible for its properties. My questions therefore are, what evidence does the applicant have that the properties were not shipped to Côte d'Ivoire by the ICR? Has the applicant inquired about his property directly with the ICR? And what didn't you call the ICR, or is it called now NIT, as a witness? First, before I directly answer these three subsidiary questions, I would like to be allowed, if it please the court, to make preliminary comments on the premise of this question. The initial statement referred specifically as to who had the responsibility of contacting Côte d'Ivoire regarding the arrest and detention of the applicant. In our view, the Vienna Convention is clear in its Article 36 when it states, and I quote, when a national of a foreign country is arrested. The article doesn't talk of who the person works with and whether the person was sent in that country as a foreign agent. It only refers, and I quote again, national of a foreign country. The respondent tried, in its oral submission this morning, to shift the burden to the ICR by virtue of the treaty establishing it. But a careful analysis of the provisions of the said treaty can't reasonably lead, in our view, to this conclusion. In the three specific questions, what is the evidence has on whether the properties were shipped? Unfortunately, honorable justices, we have none. On the second question, has the applicant contacted or inquired about his property with the ICR? Unfortunately, to the best of our knowledge, and we are not in positions to confirm this information with our client, the response is no. On the third question, as to why we didn't call a witness from that institution, we talked about it, and throughout the case of the applicant, it became apparent to us, and we believe that the letter that was sent by the UN, by the applicant to the UN Secretary General further evidenced that point, that the ICR officials were not there to assist the applicant with his case. To the contrary, we find ICR was seen by the applicant himself, and he has stated that facts in some documents and in the national proceedings. The ICR, he found them as having contributed to the violation of its own right of presumption of innocence by interrogating him and bringing him by themselves to the police stations to be arrested and detained. Under these circumstances, we felt that there was no value in pursuing an invitation to the ICR to come and testify as a witness in that particular regard. The third question, in the way that we understood it, argued that the applicant was not provided with language assistance, and if the court finds this argument as being true, to what extent it impacted on the judicial proceedings or process of the case. It is our view that we would simply not be here today as he been provided with just language assistance from the beginning of his ordeal, from the moment he was first detained by the respondent. As prescribed by the Criminal Procedure Act of the respondent, this should have happened in the first 4 hours of his detention. Not doing so, as protected by the Charter, and which is an essential component of the right to a fair trial which it protects, impeded the whole judicial proceedings in the national settings. From the initial moment he was detained, the judicial proceedings were vitiated, and it would have been provided with such language assistance. The proceedings, in our view, would have been conducted much differently. The applicant did not know or understood exactly the nature of the following element of his case. the reason for him to be detained in the first place, considering that he was only charged 12 days later, on the 18th, the extent of the possible accusation he was facing by being detained, including the gravity of these offenses, the existence of his right to have access to a lawyer of his choice to assist him in preparing his defense. And this is one of the admissions that the respondent state made this morning in its oral submissions, that the applicant was only cautioned on the 15th for the first time. That was the first occasion that the applicant learned about his right to have access to a legal counsel to assist him, not in the first 4 hours, which is the law of the respondent. Also, the applicant, would have been better placed to understand the full gravity and consequences of him giving a statement to the authorities that can later on be used against him. The African Commission, in Communication 231 of 1999, a case between Avocats Sans Frontières contre le Burundi, has held that the right, and I quote, of fair trial involves fulfillment of certain objective criteria, including the right to equal treatment, the right to defense by a lawyer, especially when this is called for by the interest of justice, as well as the obligation on the part of courts and tribunals to confer to international standards in order to guarantee a fair trial to all. The Commission later added that the right to equal treatment by a jurisdiction, especially in criminal matters, and if I may add at this stage, when the criminal matter involves a death penalty, means in the first place that both the defense and the public prosecutor shall have equal opportunity to prepare and present these pleas and indictment during the trial. That's what the Commission has referred to later on in its judgment on the communication as to be able to argue their cases on an equal footing. By not providing language assistance from the beginning of the ordeal, it had for effect of removing the essential balance of the parties and remove the essential equal footing and put the applicant at a disadvantage, which unfortunately he has never recovered from. The fourth question, the way we understood it, is you did not address the issue of property at all in your oral submissions. Should we understand that you have abandoned this claim? Unfortunately, without possibility to confer with our client on this specific issue, it is impossible for us to confirm whether we indeed intend to abandon this specific claim. This is a request that needs to be made to our client first. Sorry. Also, we are not in a position to substantiate further this claim neither. Therefore, would it please the court, we would like to refer solely to the written documents on file in this case as the basis of our claim in this particular issue. We have two questions that have been asked of both parties to answer. And the first one, in the way we understood it, is that the court invited both parties to address the court on the issue of reparations, but neither of them addressed it in their submissions. What are your views of this? The applicant was ready to proceed this morning and submit its submissions on reparations today, as requested by the court. But in consideration of the following, we didn't. The respondent was not also in a position to submit on the same, and the respondent didn't have the privilege to read our submissions before submitting its own submission. Therefore, in the interest of justice, we agreed, in conjunction with the other respondent, to delay the making of these submissions until such another time when it will please the court and in the format prescribed by the court and the timeline set by the court for us to be filing our submissions accordingly. The second question, in the way we understood it, is that there was no evidence filed by the respondent. There was new evidence filed by the respondent a few days ago. What are our views of those? We indeed received the request from the respondent 1 week ago, exactly to the day, to find additional evidence. While it was not specifically following the format set by Rule 50 of the rules, which requests to formally seek leave from the court before filing new evidence, we did not object to this filing. However, now that we have the opportunity to address the court on this specific issue, for future reference, we believe it would have been preferable to also file a summary of the new evidence to be adduced by this new filing, together with the additional evidence to be presented. Thank you.
Go. Let's see whether the judges have follow-up questions. Judge Nyungeko.
Thank you, Mr. President. Just one follow-up question. I'm not sure I understood you addressing my first question. Did you, or did I misunderstood?
Of this violation of his rights at this particular stage without conferring first with our client. We are not able neither to substantiate further the claims that were already filed with this honorable court in the documents that are in the file. Therefore, if it pleases the court, we would prefer to rely solely on the claims already in the documents that form part of the file of the court in this particular instance, and let the court decide to the validity of that claim, if any.
So you maintain the allegation as it is in the original pleadings?
We would keep it as is in the original pleadings, as per the specific request of our client. We don't know if at this particular juncture he has changed his mind about maintaining that, that violation or not.
Thank
you. Any other follow-up by honorable colleagues? Okay, very well. Thank you very much, Learned Counsel, for sticking to the time. We appreciate that. Now I give the floor to the Ms. Sarakikia, the representative of the respondent state. Or is it Mark who spoke? Okay. Well.
Thank you, Honorable Vice President. My colleague, Mr. Mark Mwamba, will be addressing the questions.
May it please you, my Lord President of the Court, and the Justices of the Honorable African Court, with deep respect, would like to reply to some of the contentious issues that have been raised by counsel for the applicants, and thereafter go straight and answer the questions that have been put to us by the Honorable Justices of this Court. First and foremost, we confirm what has been said by the counsel for the applicants on reparations. That was the position, that we were not in a position to reply to whatever submissions of reparations they would have had, because we had not read their submissions, and therefore we were not in a position to respond. Under any circumstances, we understand that it is the intention of this court to expedite proceedings, and we give the court our undivided cooperation, and we will cooperate with the court in any form that it feels best to assist it in expediting the cases before it. Secondly, we maintain that the applicant, during his time of arrest, was offered language assistance, but he denied it. According to the Criminal Procedure Act, the Police General Orders, which require a person to be cautioned and asked if he wanted language interpretation or legal representation, the interrogating officer was obliged to offer such assistance. As we stated earlier in our earlier submissions, that he was given that opportunity, he denied it, and under no circumstance could we force him to accept a right that has been provided under the Constitution of the United Republic of Tanzania and the laws. And here I specifically mean the Criminal Procedure Act and the Police General Orders. My Lords, we further maintain that the sequence of arrest from the time he was brought to the police station for questioning was in accordance with the law. It will be remembered that we never went to his residence and arrested the applicant. The applicant was brought to the police station. And we maintain, short of any other proof, that from when he was brought into police custody to his interrogation, the investigating officer and the interrogating officer complied to the heart and spirit of the law and the police general orders as he was supposed to. With regards to who had the responsibility to contact Côte d'Ivoire about its citizen being under arrest, we would like, with deep respect, to differ with counsel for the applicant. We are aware of the Vienna Convention, but our interpretation is that reading the host agreement, which is reflective, reading the host agreement between the UNICTR and the United Republic of Tanzania, which reflects the Vienna Convention, the applicant was accorded immunity by virtue of his wife being a member or an employee of the ICTR. We would like to distinguish two incidences over here. First, where a person visits Tanzania on his own accord with no diplomatic status whatsoever. Secondly, when a person is brought to Tanzania and enjoys diplomatic status and immunity with regards as per the Vienna Convention and the host agreement. It is our submission that where a citizen is visiting Tanzania on his own accord, not under privileges and immunities of an international body which enjoys diplomatic status, Tanzania would be under an obligation to inform his country. But where a person is in the United Republic of Tanzania, posted under diplomatic status, not on his own accord, but by an organ or body, we were under no obligation to inform his embassy, because the organization he was working for was enjoyed similar status or privileges as his embassy would have. And under the circumstances, it was not our responsibility, but that of the organization that placed him over here to inform his embassy, if at all they had that obligation. But if we had arrested him under any circumstance, we were bound to inform the ICTR and not his embassy, because he was here by virtue of the umbrella of the UNICTR, and not by virtue as a law-abiding citizen of Côte d'Ivoire who had visited Tanzania. Under the circumstances, we once again strongly submit that it was not our responsibility to inform Côte d'Ivoire about his arrest and detention, and if at all we had the responsibility, we were supposed to inform the ICTR, who worked on the matter in conjunction with the government of the United Republic of Tanzania, and therefore they were aware. And finally, with regard to the submission on circumstantial evidence, we do not dispute that the applicant was convicted on circumstantial evidence. As my learned friend has quoted from the decision of the Court of Appeal. However, in the United Republic of Tanzania and elsewhere in the world, circumstantial evidence is sufficient if proceeded with cautiously to warrant a conviction. And in our opinion, the courts in Tanzania, the trial court, and the appellate court proceeded that evidence with caution and therefore convicted the applicant. With respect again, once again may I kindly refer this court to an East African precedent in Tuamoy versus Uganda, and I undertake to present the court with the right quotations and quoting and a copy of the judgment. Sir Udo Udoma stated that circumstantial evidence is one of the best evidences, and it has the accuracy of mathematics. Therefore, a conviction based on circumstantial evidence is as good as a conviction based on direct evidence. Having quickly responded to the submissions of my learned friend, I would quickly like to go through the questions that were posed to us by the justices of this court. With respect, may I start with a question of Honorable Justice Mukhamulisa. She asked, is a person entitled to counsel even if that person refuses? My lady, the answer is yes. When a person in the United Republic of Tanzania is charged with a capital offense, that person is entitled to a lawyer, whether that person likes it or not. And not only in capital offenses, it has been extended to homicides. When a homicide is committed and a person and the director of public prosecution chooses to charge that person with manslaughter, that person also is entitled to a lawyer during the hearing of his case. The rules of recording a statement and having a person of the choice do not change. They remain the same as per the Criminal Procedure Act. With regard to at what stage was an interpreter provided, the answer to that is that the interpreter was provided during the trial in the High Court. But as we demonstrated in our first round of oral submissions, the applicant chose to deny the services of that interpreter, although he was availed during the trial and was ordered by the court to translate or interpret from Swahili to English to French and vice versa when necessary. As we demonstrated earlier on in the first round of oral submission, although that option was available, the applicant chose not to take that option. As democratic as we are, we could not have forced him, and the court could not have forced him to take that option when he was confident, he was comfortable with the proceedings and whatever was going on in court. With regard to what is the reason for the Court of Appeal's silence on the appeal, my lady, appeal number 242 of 2010 was heard, and judgment on that appeal, which is judgment from the conviction of the High Court, was delivered on January 28, 2014, and the court upheld that conviction. He filed an application for review, number 8, that was heard, and on the 19th of May 2016, a decision was made on that application which was to strike it out. However, during that period, he prayed to have legal representation, and the Court of Appeal said yes, he could have legal representation, but based on the circumstances of the case, it was dismissed, and the court decided it would not prejudice the applicant in any way. He filed application number 9, which was later on struck out, and leave to refile another application in the court was granted, and that was granted without regard to limitation of time. Application number 3, which was later on filed by the applicant, is now scheduled for hearing on the 18th of July 2018 before the Court of Appeal in Arusha, as per the cause list that we have already filed as additional evidence. With regards to the question of Honorable Justice Mengue, I hope I'm pronouncing that correctly. I apologize if I'm not. What treatment is meted out to a detainee, especially who is sentenced to death? We understood this question to contain 2 parts. First, a person who is under detention. Secondly, a person who has been sentenced to suffer death. With regards to a person who is under detention, the Constitution of the United Republic of Tanzania clearly states that no person shall be presumed guilty. It states that every person shall be presumed innocent until proven guilty by a competent court of law. So that is one of his rights. He has the right to be presumed innocent until he is proven guilty. But he also has the right to be taken to court within the specified time, over the specified period, as per the law. Thirdly, he has the right to be treated with dignity and respect. This is a constitutional requirement, and it goes to the heart and soul of Tanzanian values. He also has the right to have a person of his choice available or present when he is recording his statement. He has the right to be visited by a person of his choice and a lawyer while he is in detention. With regards to a person who has been condemned to suffer death, first of all, they are not subjected to any sort of labor. According to the prison general orders, they are given the right to access information, and we have been trying to improve on a daily basis on that level, like newspapers, having television sets in so that they can have access to the outer world. They are allowed to exercise. They are allowed to access medical facilities. They are granted 3 meals a day. They have the right to be visited by their lawyers in case they are pursuing a review, but they also have the right to be visited by their friends or relatives according to the timetable that has been set by the prison authorities. But above all, they have the right to worship. This, without regard to your religion or your faith, they are accorded the right to worship according to their faith. With regards to the question raised by Honorable Justice Matuse about the powers of the court to order release and the powers of the court to order restitution, with regards to the powers of the court to order release, I humbly draw the attention of the court to its own decision in Alex Thomas versus the United Republic of Tanzania, in which the court said an order for release from prison can be made under very specific and compelling circumstances. Under very specific or compelling circumstances. We do not contest the power of the court to do so. But under the circumstances in this case, our argument was there were no specific or compelling reasons for the applicant to be released in case, now here is speaking hypothetically, but in case it is prudent for the court, there are no specific or compelling circumstances that would warrant this court to order release. However, we do not contest that the protocol and provides and grants the court such powers. With regards to Article 27, we do not contest Articles 27. My Lord, with regards to restitution of property, our argument is that it has not been proven that Tanzania violated or has the property that belongs to the applicant. And as we argued earlier, we did everything in our power based on the host agreement and the Vienna Convention to dispose of the property that, under these circumstances, we argue belonged to the deceased and the applicant enjoyed by virtue of being the deceased spouse who had diplomatic immunity. So our argument was it would be unfair to order the United Republic of Tanzania to restitute something that is not in its possession. It has never had that property. It complied with the host agreement and the Vienna Convention, and that's why our argument was trying to implore the court, in circumstances they found violation, if at all there were, not to order restitution of property which is not in our possession. And well, that was our argument. We apologize if it didn't come out right the way we expected it to come out. With regards to the question raised by Honorable Justice Nyungeko, as we stated earlier, I think I started my submission with joining hand submission of my learned brother for the applicant, and I think that question is more or less answered, unless your lordship you have any follow-up question. But we are committed to working with the court to ensuring that applications are dealt with in a timely and fashionable manner. My Lord President, Honorable Justices of the Court, I thank you for your attention. I humbly submit, and that will be all. However, I avail myself to you if you may have any follow-up questions that you need me to clarify. Otherwise, I humbly submit.
Yeah, I thank you, Mr. Mulambo, for also keeping to the time. Now, I will ask my honorable colleagues whether they have follow-up questions. I think Judge Ben Saula first, and then.
Monsieur le Président, bon, ce n'est pas une question du suivi que j'ai à poser, mais je n'ai pas eu de réponse à ma question principale. Je disais que ce n'est pas une question de suivi que j'ai à poser, mais je n'ai pas eu de réponse à ma question sur la garde à vue et les obligations de celui qui doit exécuter la garde à vue. Je n'ai pas eu de réponse à cette question. Merci, Monsieur le Président.
Well, just hold on. Any other question? Judge Nyungeko?
Thank you, Mr. Vice President. We have taken note of your response to the question on the treatment of detainees. Yes, we have taken note of that, but what is your response to the allegation of the applicant on cruel and inhuman treatment of the applicant in the present case?
Okay, you got that? your response on the issue of cruel, inhuman, and degrading treatment of the applicant by the respondent state. Okay, then you can respond to the two questions.
May I start, my lady, by begging for your indulgence on the question of the detention. And please forgive me if I ask for clarification. I am not certain what aspect of the detention are you asking? Is it what are the conditions for the detention, or what is the procedure for the detention of a particular person? Because in order to reply to your question, I again apologize. I have to ask for clarification once again, if it's okay with you.
La question concernait la garde à vue. La garde à vue, elle a ses conditions. La question ne concerne pas les conditions de cette garde à vue. Elle concerne les conditions dans lesquelles la personne gardée à vue est en garde à vue. Quelles sont les conditions? Est-ce qu'elle a le droit de recevoir des gens, de manger, de dormir, des soins médicaux, etc. C'est ça le but de la question. Ce n'était pas de savoir dans le code de procédure pénale quelles sont les conditions pour mettre quelqu'un en garde à vue. Non, une fois que la personne est mise en garde à vue.
From where I sit and listening to the interpretation into English, you mean, in other words, what are the conditions of custody immediately after arrest, up to and before somebody has been charged in court or presented to court? That is the question.
Thank you, my lady, and thank you, my Lord Vice President, for clarifying the question. When a person is arrested, may I start to saying that when a person is arrested, if it is an offense that is bailable, meaning that the police chief is empowered by law to grant bail, or the officer commanding station, that officer, once the applicant requests bail, is required to grant bail. If it is an offense that bail has to be given by the court, within 24 hours that person is supposed to be taken to court. If it is an unbailable offense, and here we're talking about crimes under the Economic and Organized Crimes Control Act, and capital offenses, the person is supposed to be taken either way to the court within that prescribed period pending investigation of the matter. Now, while this person, regardless of whether he has committed a bailable or unbailable offense, there are certain rights that this person has. For instance, the right to have a person of his choice available or present when that person is recording his or her statement. They also have the right to request a lawyer to be available when they are recording their statement. Thirdly, they have a right to medical examination if they complain under any circumstance that they are in pain. These rights do not go away simply because a person has committed a capital offense. Regardless if it's a bailable offense, a non-bailable offense, the person still has the right. The only difference perhaps will be if it's a bailable offense, the officer commanding station would want you out of his station very quickly and give you bail so that you can go and get yourself treated. But if it's a non-bailable offense, then it would fall upon the police to make the necessary arrangements to make sure that you go to a medical facility and get the treatment that you want. But while you're in custody, if you have a relative or a lawyer who wants to see you, then you would have to be given that right, and under any circumstances, that is what happens. Now, with regard to the, I hope I've answered at least to some satisfaction that question. With regard to the question that you asked, my Lord, about allegations on cruel and inhuman treatment, I want to be very honest over here as to what amounts to cruel and inhuman treatment. If cruel and inhuman treatment amounts to a person being put in a cell with 5 other people, if cruel and inhuman treatment means a person being held in temporary custody, being given a 3-inch mattress to rest their body upon, if cruel and inhuman treatment means sharing a latrine with the others, if cruel and inhuman treatment means not giving every person who has been arraigned or brought to the police station with a mosquito net, then perhaps I doubt Tanzania would not be guilty of cruel and inhuman treatment. But if cruel and inhuman treatment is interpreted to mean that a person is not treated with disrespect, if it means that a person is treated with all the human dignity that they have to be treated with, if it means that a person is given the opportunity to have a person of his choice, if it's access to a lawyer, my Lord, I humbly submit that there was no cruel or inhuman treatment on part of the applicant. I don't know which standards you are looking at, but based on our African standards and the United Republic of Tanzania, all the circumstances put together, if he was treated with respect, with dignity, then, my Lord, I think we humbly submit that there was no cruel and inhuman treatment. Bearing in mind that the prison and the police cell cannot be as luxurious as we would wish it to be. It is a place that most of us don't desire to go, although we would wish, even if we do go, it was a little bit comfortable than it is. But we submit that we did everything that was necessary to treat the applicant with humanity and respect. That is all, my Lord, unless there is any other follow-up question.
Thank you very much. Any follow-up question? Okay, I think there are no follow-up questions. The responses or the answers that have been given by the representatives of the applicant and the respondent should be put together in the form of a brief to be submitted to the court within 7 days. So you have 7 days within which to submit to the court the answers you have given to the various questions. You submit to the court within 7 days. Now, with regard to the issue of reparations, that both sides were unable to address during this public hearing, as expected by the court. The court will decide on the way forward, and you'll be informed. There will be two options. One option will be for the court to make an order or to inform you that you should submit a brief on reparations within a determined period, and the respondent would have time also to respond within a determined period. And that will be if the court decides to consider it together with the judgment, without making, and that will not be an indication that the court has decided is a violation, no. It is for the court to shorten the process, as was explained this morning. So the court could decide to go on that route, or the court could also decide to make the judgment first, and then proceed as a second stage to reparations. And the court will decide, but whichever case you will be informed. Okay, thank you very much. And we also want to thank the other persons who came to listen to these proceedings. Thank you very much. We come to the end of this process.